IPR policies
Hello.
and its international framework, a global perspective. You have
Uh,
been listening various
Sir, am we audible, sir?
aspects of intellectual
Hello,
property
sir.
for
S- Hello, sir.
so
Are
many
we
days.
audible? I
So
think he
just
is not audible.
I'm not going to discuss something which is very cutting edge area. Rather, I'm going to discuss things which is very basic in nature, and it is very important to have a very clear understanding about the whole idea of intellectual property rights, how yes, Jayanta, can you speak something so I can?
oh,
Sir, are
okay.
you able to hear us now?
Yeah, I can hear you, ma'am.
So before you continue with your lecture, we wanted our participants to know more about you as an introduction. So I would like to call Minakshi. Please ask your classmate to introduce herself.
Okay.
Okay, ma'am. Thank you so much. Good afternoon, everyone. I'm Meenakshi Sharma, LLM student of Department of Law. I
Yes,
welcome
sir.
you all to the post-lunch session of the third day of Faculty Development Program on IPR. Today's resource person of this session is Dr. Naveen Kumar, sir. Sir has joined us. He will be sharing his expertise on the topic IPR, policies, and international framework, a global perspective. Now I call Sri Prakash, LLM student of Department of Law, to introduce the resource person.
Good afternoon, everyone. It is my great honor to welcome you all to this faculty development program organized by the Department of Law, Central University of Karnataka. Today, we are fortunate to have with us a distinguished academic and expert in the field of law, Dr. Naveen Kumar, who will be sharing his knowledge and insight with us. Dr. Kumar is currently serving as an associate professor in the Department of Law at the Northeastern Hill University, Shillong. He holds an impressive academic background with a BCom LLB, LLM, and a PhD in law. His areas of specialization include corporate law, public health law, education law, comparative constitution, judicial process, environmental laws, human rights laws, customary laws, and cyber laws. Before joining academia, Dr. Kumar worked as an advocate with the United Chamber of Law, a renowned corporate law firm in New Delhi. Sir then transitioned to teaching, where he has dedicated over 15 years to undergraduate teaching and more than 5 years to postgraduate and PhD supervision. We are truly privileged to have him here with us today, and we look forward to the invaluable perspective he will share in this session. Let us extend a warm welcome to Dr. Naveen Kumar. Thank you, sir.
Thank you. Thank you, Mr. Sri Prakash, for introducing me because uh, because of the technical glitch, I could not able to hear you, and I thought I have been delayed, so I should directly start my lecture. Thank you for giving me such good introductions. Although, just I would like to tell you ever before delivering lecture that to become a superpower and to join a league of developed nations, we need to think very, very seriously in the area of intellectual property rights. And that's why this subject become so important for all of us in last 20 to 30 years. Policies of the government of India is also towards more and more protecting our traditional knowledge, protecting our copyrights, enlarge the ambit of trademark, restrict the infringement of trademarks, because we cannot develop, we cannot market, exploit the market without achieving significant position in the world as far as the arena of knowledge creation. So in this perspective, we must need to have a very robust law. We must need cooperation at national level and international level, because the concerns and challenges of intellectual property rights are of global in nature. So even if you have a very robust law, but if there is no international cooperations, protections available, your resources can be appropriated any other part of the world. So in this perspective, I'm going to only look at that what are the important formulations we have derived in the last more than 100 years as far as international and global perspectives of intellectual properties are concerned, because the topic assigned to me is an IPR policy and its international framework. So without a global perspective, without giving much emphasis on other aspects, we should start discussing on our presentations. So I'm going to share my presentations with you. Just to hold on for a few minutes.
Sir, also one more information I have to share with you about this session. That this session is for 2.5. If you have preferred to have a brief break between the session, so we can have it.
I can understand that a post-lunch session, 2.5 hours, will be very taxing for all of you. So I'll try to make my presentation very brief, to the point, and we spare enough time for discussions so that your understanding and your memories can be refreshed. So certainly I understand your important concerns also. So I'll try to finish it as early as possible, maybe between 1.5 hours to 2 hours. I'll try to sum up my presentations. Okay, I'm sharing my slide.
Okay.
My screen is visible to all of you?
Yes, sir. Yes, sir.
Yes, sir.
Yeah. Because of technical network issues, I'm closing my video. So the topic given to me is IPR policies and international framework, a global perspective. On these aspects, I'm going to discuss with you that why it is so important that globally that we should have a very robust, very vibrant, very effective laws available at a national level. At the same time, such laws also need to be protected at international levels. When we talk about intellectual property rights, basically we refer to the legal rights granted to the individuals, organizations who created the intellectual property. And there are large number of intellectual outputs created by the inventors, and those creations need some legal recognitions. These recognitions are in the form of patent, literary and artistic works, safeguarded in the form of copyright. Once a company create a big brands need protections in the form of trademark. Industrial designs are very, very important in the business world. Though industrial designs need to be protected. Another important aspects is which serves the individuals and the community or the protect the interest of the company, that is trade secrets. So broadly, we are going to discuss the patent rights, patent of individuals or corporations, because corporations are also owner of the patent rights, license owner of the patents. So copyrights individually at a organizational level also, the owns the copyright. Trademarks is also very, very important at a national level, at international level. Industrial designs also need to be protected. And the trade secrets are also one of the important intellectual property. Why? All of you well aware about all those things, but before discussing, I want that just we should refresh our understanding that why we need protection at a global level. When we talk about IP laws, it provides creator with the exclusive right to use, distribute, or commercialize their creations. This is very, very important because these rights are available for a limited period of time. Patent rights, certain period of time. Copyright has a certain period of time. You know, the trademarks, frequent re-registrations are required in the locations. So certainly the intervention of law is necessary to protect the interest of the creator of those intellectual property. So it is only available for a specific period, and it ensures recognition and the economic benefits, because certainly for the creation of these intellectual property, huge resources is required. All of you know that for a drug discovery, it took 10 to 15 years from lab to market. If any drugs comes to the market, this process of 5 to 10 years period is there. So imagine the huge research and development costs involved in bringing any medicines into market. Suppose a individual is writing a book. It took years and years to bring it in the shape of book. And if their copyrights are not protected, so their rights are infringement. So that's why this legal framework encourages innovations by offering a secure environment for inventor and artists to share their ideas. Imagine if this kind of intellectual property protections would not have been there. People would not have shared their idea freely. They have a fear in the mind that if they share, somebody will appropriate. So this is a kind, this protections, intellectual property protections, they give a kind of security in the mind of the inventors that once they share their knowledge, certainly their rights is going to be protected. Their intellectual property cannot be appropriated because well-established procedure is there, well-established laws are there. So this is the another important aspects that these recognitions are also required at a not only at a national level, at a global level also. Another aspects I would like to share with you, that is intellectual property is fundamental in fostering economic growth. Suppose if any nations wants to develop, they need a technology. They need a scientific know-how. And for that, huge expenditures incurred for acquiring those know-how, those research and development. So there is a need to market those benefits which arise out of their huge expenditures. So it is important for the economic growth. Suppose a country need let's take example of EV vehicles we need, because the condition of pollutions and is increasing day by day. So we need a technology by which the vehicular pollution can be reduced. Certainly, we need a very advanced, the EV technologies to fuel the cars and other vehicles through batteries. And certainly, for economic growth, also we need these intellectual property, and that's why there is a need to promote creativity is also very important. Protecting cultural and technological advancement also requires huge intellectual property. So that's why we can say that it's a play a crucial role in international trade, where country rely on a standardized IP system for technology transfer, cross-border collaborations, and resolving disputes. Three important aspects I would like to discuss with you. That is standardized IP system for technology transfer, because technology need to be transferred. Suppose now you will find it that when two companies are entering into collaborations, they only enters into agreement to sharing of their technologies, because technology is very, very important for the development of any country, any society, or the running of any businesses. So technical know-hows requirement of these companies are certainly increasing day by day. So IP system protects the creators. Then all of you are aware of various technology transfers, then how the big multinational corporations are always looking for new innovative technologies, and how they acquire the various startups, how they fund startups ecosystem. Because to run a businesses, you need a huge innovative technology to encounter with the new challenges. And one of the very important area you might have aware of artificial intelligence. Then I'm just giving you one example that how technology play a very, very crucial role. I'm just taking you 2-3 days before example. One very important company, global American company, is NVIDIA. And what happened when the Chinese company come up with a very effective technology in the area of artificial intelligence? Because you might have heard the speech of President Donald Trump, and one of his strategy to develop their country as per their expectations is that how to become the leaders in artificial intelligence. And what happened when China started you know creating a threat to their positions? The share price of NVIDIA on very few days back, 2-3 days back, fell down around more than 13%. Because the why I'm sharing this example to make you understand this, that technology is an area which is very dynamic, very vibrant, very disruptive in nature. And certainly for development, any nations, to develop any society, any country, very strong technology is needed. And we have already seen the importance of technology during COVID time. When such disruptions was there, technology was the only medium by which people were connected, they could able to perform various functions. So what I would like to tell you, that technology transfer is also very, very important aspects of the regulation of the intellectual property at international level. Cross-border collaborations are equally very, very important. Today we have so many beautiful cars, the available in our country because of the cross-border collaborations. First important example is Maruti Suzuki. Any companies in any area you may look at it, there are so many collaborations are there for providing better goods and services. So this is also very, very important when we talk about cross-border collaborations. Another important is resolving disputes. Wherever money is there, wherever intellectual property is there, chances of dispute is also there. Who owns property, they have to face disputes also. And same thing, intellectual property, in the case, it also happens in the case of intellectual property. You also have seen so many cases has been filed by the intellectual property owners that others have started misappropriating their intellectual property. They started copying their, infringing their intellectual property, violating their IP rights. So if any dispute arises, how to resolve these disputes, that is also very, very challenging, not only at a national level, at a global level also. Another important aspects about the whole aspects I would like to discuss with you, that is globally how intellectual property drive research. Imagine if this kind of protection would not have been given, the people were not interested to do more and more research. Because when you publish an article, your article has a copyright protection. No one can copy it. Plagiarism is there. Without recognizing that person, no one can, they take their ideas for their other writings. That's why in the research writings, you might have seen that.
Sorry, sir,
the-
for the interruption, sir. Actually, sir, your PPT slides are not moving because we are just seeing the first slide.
Yeah, I have not moved. I'm just,
Okay.
I have not finished the first slide. The second
Okay.
slide also I will start. First, I have to discuss about the first slide only. I'm well aware of it. Don't worry.
Okay.
Thank
Okay.
you. So globally, IP drive research entrepreneurship and competitiveness, underscoring its importance in shaping modern economies and safeguarding the interest of a creator and consumer alike. Because it is very, very important at a global level also how to maintain competitiveness. I have told you that technology world is full of disruptions. Why? Because of competitiveness. In the startups, in a small entrepreneurship, we are also challenging the big technology companies that our Indian startups are also doing very well, because we have to be very, very competitive. Then only people will consider our products, and that's why you might have seen that competitiveness IPR promotes research. It promotes entrepreneurship. Just you imagine a person, Flipkart, market cap of Flipkart is more than 1 lakh crore. The Zomato 1.5 lakhs crore listed in the Indian stock exchange. Just you imagine Zomato is a platform, is a technology company, how it promotes entrepreneurship. It also promotes competitiveness, and modern economy is shaped on intellectual property. So certainly there is a need to protect the interest of creators and consumers also. So before discussing the intellectual property rights in a detail, first of all, I would like to discuss about the definition part of IPR. When we look at the definitions, World Intellectual Property defines the IPR, that is the creation of mind, such as inventions, literary and artistic work, design and symbol, names and images used in commerce. So WIPO try to define what do you mean by, because when we talk about IPR, what do you mean by, what is the definitions of the IPR? So Of course, it's a creation of a mind. It is an inventions, literary and artistic work, designs, symbols, names, images used in commerce. All of you are well aware, just I'm highlighting it. Another important definition was given in the TRIPS agreement, Article 1, Clause 2, which defines IPR. It says, intellectual property shall include all categories of intellectual property that are subject of Section 1 through 7 of Part 2, namely copyright and related rights. Even if you, in TRIPS agreement, they talks about the intellectual property rights, talk about copyright related rights, trademarks, geographical indications, industrial design, patents, layered design of integrated circuits, and protection of undisclosed informations. So TRIPS has also defined in a similar way. Prior to TRIPS, we should also look at the international conventions, old conventions, Berne Convention and Paris Conventions. Because when we talk about international perspective, we cannot forget these two important conventions, which has shaped the intellectual property at established the intellectual property at a global level. So what is written in the Berne Convention for Protection of Literary and Artistic Work? That is, this treaty was signed in 1886. Article 2, Clause 1, if you look at it, it says, the expression literary and artistic works shall include every production in the literary, scientific, and artistic domain, whatever may be mode or form of its expression. So certainly, in the intellectual property, we are protecting the various form of the expressions. When you look at the another important definition given by the Paris Conventions for the industrial property, so the Berne Conventions define that what they mean by intellectual property in the form of literary and artistic work. When we need to find out definitions, we look at these conventions, and various member nations are bound by the various terms and conditions. I'm not discussing Berne Convention in detail. Just I'm looking at that at international level, there is an agreement among all the people that what do you mean by artistic work, literary work. So every production in the literary, scientific, and artistic domain, whatever may be mode or form of its expression, that would be called intellectual property. Come to the Paris Conventions. Article 1, Clause 3 says, industrial property shall be understood in the broadest sense. What is the definition? Broadest sense. And shall apply not only to industrial and commerce proper, but likewise to agricultural and extractive industries and all manufactured or natural products. So very wide ambit is given in both Berne Convention and Paris Conventions, because when dispute arises at international level, you need to define that is it intellectual property? Because when you talk about violation of intellectual property, you need to prove that whether the individual or corporations have this intellectual property. When we talk about intellectual property, what is the definition of such intellectual property? That's why I have looked into the definition of the intellectual property given by the various international organizations through various treaties. So I have only highlighted 4 important treaties under my second slides. Come to the very important aspects of the IPR, that why we should give so much attention to IPR. How benefits, economic, intellectual benefits derive out of such intellectual property rights. For that, I have made certain few points to understand the importance of IPR. First of all, it incentivizes innovations and creativity. Because if someone owns IPR, he feels that he can exploit this intellectual property rights for a certain period of time. For copyrights, the life plus 60 years. After death also, this rights is available, copyrights issues. Suppose if any movies is produced on their literary creations, they will get the economic benefits. If any technology is transferred patent is transferred up to 20 years, this right is available to the inventors or the company to give a license to do that. So certainly it incentivizing the innovations and creativity. Assuming that if such protection would not have been there, such innovations and creativity we would have certainly missed in our society, country, or in the world. So IP grants created exclusive rights over their work, encouraging innovations by ensuring recognition and financial reward for their efforts. So certainly that is very, very obvious for incentivizing the innovations. Another important is fostering economic growth. Why? Because why people are so much worried about IP, intellectual property, because it is one of the important aspects for the economic growth. That's why our Honorable Prime Minister, whenever he addressed the youth of our country, always they say that you need to create a pool of intellectual property, because for a development we need advanced technology to deal with the problems. He always requests the students that go for innovations. Rather, the consumer of technology, we should become a producer of technology, because for economic growth, we need to have a very robust intellectual property system, because it has a potential to drive GDP by boosting industries like technology, pharmaceuticals, entertainment, contributing significantly to national economies. So IP has a potential to protect, promote GDP growth. It has a potential to, develop the nations, bring more investments to that country or states. It promotes economic growth in nutshell. Another important importance of IPR is globally and nationally, that it's securing competitive advantage. When companies use IP rights to protect proprietary technologies, branding, and processes, helping them maintain a competitive edge in global markets. So the technology is the only important aspects which create edge in the global markets. So that's why it promotes, every company is always looking after new and innovative technologies, because if you want to be in a race, you have to be in innovations. If a company have a more and more intellectual property rights, then only they will continue for a longer period of time. I would like to give you, the moment you could not match in the race, you will be ignored, you will be left out. The best example is Nokia phones. When telecom industry was revolutionized globally, Nokia was the biggest player. Now Nokia is no more a very prominent player in the whole technology world. So many, the companies, they become, the issues of a history only now, because they could not able to compete in the technological race. So it's a very, very important, because if those companies will survive in future, those who have IPR policy, those are having very vibrant intellectual property. They are able to create more and more intellectual property, then only they will survive in the cutthroat competitions. Another importance of IPR is that is facilitating research and development, because intellectual property incentivizing investment in research by guaranteeing return, leading to groundbreaking advances in science, technology, and medicines. So certainly IPR, they facilitate more research and development. Another aspects which I believe that IPR is playing very, very important role is international trade and collaborations, because certain companies thinks that without such technology we cannot reach us to the large audience, large people of the world globally. So they need such a important intellectual property that could able to help them in global trade. And certainly this intellectual property play a very pivotal role in global trade by standardizing rights, fostering cross-border collaborations through licensing and technology transfers. So there is a mechanism of transferring technology through licensing. technology transfer agreements are there, how to share the benefits between the two companies working in a two different part of the world. So these things are very, very important. That's why IPR becomes so important for every companies, individuals, country, because every country want to be in the league of developed nations, because we are also aspiring to become a developed nations by 2047. And that's why we are trying that our intellectual property, we should be be in the leading players of creator of the intellectual property in the world. So globally, then only our recognition will improve. We could able to harness those technology for the upliftment of the people. So that's why it also of a great importance for the the country nations also. When we talk about IPR, I would like to give you in initial lecture, I told you that the importance of this subject is of very new for developing nations. To understand the historical development of IPR, I would like to discuss with you that intellectual property's beginnings is of very ancient origin. It is not something that it has been started very recent journey. That's why I would like to discuss with you that historically also, the IPR was there, intellectual property was there, and certainly in a different form. Codification was not there in the way we are looking all these intellectual property today globally at a national level or at international level. But beginnings started uh, even during the Roman period. That's why I have discussed with you that the origin of IPR can be traced to even ancient societies where creators were informally rewarded for their contributions. In ancient Greece, awards were granted to chefs for unique recipes, reflecting an early understanding of rewarding creativity. Similarly, Roman law included provision for protecting literary and artistic works, offering recognition to authors. While these practices were not codified into formal laws, they set a foundation for the idea that intellectual contributions deserve acknowledgement. So what I would like to say that it was not available in the codified form, but if someone was a creative, the creativity attracts reward was there during ancient time also. So, I just highlighted 2-3 examples like safe example, that if someone created a very good recipes, then he was awarded. If someone, they created some literary and artistic work, recognition was given to the authors. Come to the Middle Age. During the Middle Age, Europe saw the rise of guilds, which regulated the production and sale of goods. These guilds function as a precursors to modern intellectual property system by protecting trade secrets and ensuring the quality of goods. For example, master craftsmen closely guarded their method and design, passing them down only to trusted apprentices. While this approach was limited to specific trades, it introduced the idea of a controlling intellectual contribution from economic and social advantage. So the kind of quality control, kind of innovations was also available during the Middle Age. And certainly, the peoples were getting advantage of having better quality product, ensuring quality, all these things were there. Because this is one of the important aspects of intellectual property. Now come to the age of Renaissance. From there you will find it, the real beginning, real in the sense that in the codifications of the patent and copyright laws started. That's why we'll say that it's a Renaissance period of a patent and copyright. So Renaissance period witnessed significant advancement in science, art, and technology, which demanded more structured mechanism for protecting intellectual contribution. And that's why Vincent Patent Statute of 1474, often regarded as the first formal patent law, laid the groundwork for modern IPR. This statute granted inventors exclusive right to their inventions for a limited time, provided the inventions were novel and useful. So this, when you look at this period, you'll find it the basic idea of a patent emerged during this period. And Venetian system recognized the importance of encouraging innovations while ensuring that society eventually benefited from the shared knowledge. When you come to the same period, you'll find that the invention of the printing press played a very, very important role in protecting the intellectual property. And that's why Johannes Gutenberg revolutionized the dissemination of knowledge and ideas. However, it also led to widespread copying of books and manuscript. The address these early copyright laws were introduced. The Licensing of Press Act was one of the very important legislation of 1662 in England, aimed to regulate the printing industry by granting exclusive right to publishers. Though it primarily served censorship purpose, this gradually evolved into more author-centric laws, culminating in the Statute of Anne, that is 1710. This landmark legislation is considered the first modern copyright law, giving author exclusive right to their work and laying the foundation for contemporary copyright system. So you'll find it that in the 14th, 15th century, 16th centuries, early 17th century, also having copyright laws in the form of, intellectual property laws in the form of copyright protection, patent protections were there. Certainly, the requirements changed in the 18th and 19th century, and then formalization of the whole new form of intellectual property laws, derived from those industrial revolutions. And that is the turning point of intellectual property right. Because for the industrial revolution, rapid technological advancement started, and that was necessary for, the more industrial growth. And certainly intellectual property put a challenge on it. So that's why you will find it, one of the great inventions was the steam engine, cotton gins. Eli Whitney's cotton gins revolutionized the industry. It also highlighted the need for robust patent system. Nations began formalizing their patent law to incentivize inventors while promoting economic growth. By 18th, 19th century, only we have realized that we cannot develop economic growth is not possible unless they incentivize the honor of the intellectual property. And that's why there was a need of very robust, vibrant patent protection system. And that's why the beginnings started. And during that period, you will find that trademarks emerged as a very important IPR. As a mass production grew, companies sought ways to distinguish their production in competitive markets. This led to enactment of Trademark Registration Act of 1875 in the UK, because trademark play very, very important, because authentication of the goods is most important aspects in the commercialization of the goods. So how it can be authenticated? For certainly mark play very, very important role. I think all of you recognize the Apple phones or Apple computer, Apple laptop easily without any much difficulty, because that Apple, the shape, size of Apple is sufficient enough to protect the commercial interest of a company. So similarly, the trademark registration played a very, very important role in protecting the brand identity. And the trademark become essential for maintaining consumer trust and ensuring fair competitions also. So because at the same time, the consumers' interest need to be protected. At the same time, manufacturers' interest also need to be protected. And that's why trademark played a very, very important role in doing that. When you look at the Industrial Revolution played a very, very important role in rise of international trade. And because of that, the cross-border recognition of intellectual property rights started. Because all of you aware that you cannot start a company in the name of Apple in India, although Apple Company Corporation is registered in America. So this cross-border recognition of intellectual property rights is very, very important, because otherwise whole protection become meaningless. Suppose in India intellectual property is protected, if China start copying it, how it mean? They started selling the product throughout the world, exporting the whole world, or any country. In one locality your product is protected, other countries started selling that, copying your designs, started selling, started commercializing your product. So how to protect it? For that there is a need of certain kind of the bilateral multilateral agreement, and that is the area where the globalizations was played very, very important role in protecting the IPRs. While early efforts were largely bilateral, initially two countries were entered into agreement, then global cooperation was also laid on this area, because intellectual property cannot be protected unless there is an international framework for IPR. So that's why when we study the historical aspects of the IPR, we start studying the post-industrial revolution. That's why, so just for historical understanding, we can say that intellectual property was there in the ancient period, also medieval period, but real crux of the real, important features of intellectual property, economic benefits derived out of intellectual property, started post-industrial revolutions. And that's why the two important landmark treaties played very, very important role for the protection of the intellectual property. For one is the Paris Conventions and Berne Conventions. All of you are well aware. Just I'm highlighting what is the main protections given under the Paris Convention. This treaty was the first major international agreement on IPR, providing reciprocal protection for patents, trademarks, industrial design across member states. It introduced the principles such as national treatment, ensuring foreign creators receiving the same protection as domestic ones. This is one of the important aspects agreed by the all member nations, that there should not be any discrimination at a global level. The national treatment is there, and foreign creators also receive the same protection as domestic ones. So it gives a huge market. Once a intellectual property is created, that property can be treated equally throughout the world, those who are the member nations. So that is one of the important development took at international level by Paris Conventions. Again, I'm telling you that when you look at the global perspective, you cannot ignore these two important foundational work developed the recognition of the intellectual property at a global level. Second important convention is the Berne Convention for the protection of literary and artistic work. This was signed in 1886. It only focused on copyright. This treaty ensures creators' rights were protected in all member countries without requiring formal registration. It established principles like automatic protection and moral rights, shaping the modern copyright system. Whatever copyright system we are following, the genesis and basis is the Berne Conventions. So these treaties mark the beginning of global cooperation in IPR, recognizing the need for standardized rules in an increasingly interconnected world. So these two treaties shaped very, very important protections globally to the creators of the intellectual property. Now come to the 20th century, what type of development took place? The pace of intellectual property increased manifold post World War II. Why? Because there was a race to be developed in the League of the Developed Nations, and technology played a very, very important role in developing any society. So what happens? The aftermath of World War II brought renewed focus on international collaboration and institutional building. The first is the establishment of the WIPO in 1967. One international body was created, how to coordinate the intellectual property, the issues must be resolved at a global level. So one organization was created in 1967 in the form of WIPO under the United Nations, marked a significant milestone. WIPO aimed to promote the protection of intellectual property worldwide and harmonize national. These two functions is very, very important. There must be harmonization of a national laws. Suppose a nation is a sovereign, they pass a such intellectual law that in India, we are not going to recognize any of the intellectual property. So certainly, if a nation, sovereign nations is not willing to act protection on the intellectual property, it cannot be protected. If these organizations play a very, very important role in suggesting nations that you must have protection of intellectual property. Otherwise, we'll not enter into technological transfer. We do not cooperate on certain other matters, because you might have seen that whenever two countries are meeting, they always sign that the promote intellectual property rights protections. America is always threatening country like India and Asian countries that those peoples are not following very robust regime of intellectual property law. So, because of not having very stringent intellectual property protections, they are losing, a lot of economic resources. So certainly, one organization was created to deal with all such issues, differences, the challenges, to deal with the global perspective of the intellectual property. And you'll find it that there was a certain international agreements also emerged to address specific areas of IPR. And one is the Universal Copyright Conventions, 1952, provides an alternative to the Berne, accommodating countries like United States, which has not ratified the latter. Additionally, agreements like Rome Conventions. Additionally, agreement like the Rome Convention extended protection to performers, producers of the phonogram and broadcasting organization, reflecting the growing complexities of the IPR. So you'll find that apart from these two, the multilateral treaty, other treaties are also required, and in Universal Copyright Conventions, Rome Conventions also you need. Because why I'm telling you, majority of you are a teacher, because when you are teaching intellectual property rights, the student might ask you that we are studying the national legislations. Why we need to study all these conventions? Because these national legislations are meaningless. If
Sorry for the interruption, sir. Actually,
yeah,
sir, the participants are asking if the slides are moving or not.
yeah, it's moving.
Okay, 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 sir.
Yeah. So when we talk about the
We are not able to see. It is just the first slide that we are seeing still.
still first slide only. Okay.
Yes, sir.
Now, is it visible to you?
No, sir.
Only the first slide, sir.
Okay, 1 minute. I'm sorry. Is it visible now?
Yes, sir.
Yes, sir. Now we are on the fourth
Fourth, no?
historical development
Yeah,
of
yeah.
IPR. Yes, sir.
Yeah. So, okay, I have discussed third slide, fourth slide, all these slides. If you want, should I share with you? I'll share with you PPT, don't worry. After presentations, I'll share with you. So I have now you can see these slides.
Excuse me, sir. Just you
Yeah.
make it in a presentation mode so that it will move, sir. It is not in presentation mode.
Okay, okay. Okay. One minute. I'm just actually, and I have shifted my computers. Now it is visible.
It's visible.
Yeah. So can you see the 4.6 slide?
Yes, sir.
Okay. Thank you. So when we talk about the modern era, that modern era, when we categorize it, we talk about the 20th century. And certainly, so when we talk about the historical development, now I have categorized it in a 20th century onwards as in a modern era. So when you look at the 20th century, saw the digital revolution, which transformed the landscape of intellectual property. The advent of computer, the internet, and digital media pose new challenges of IPR system. Issues such as digital piracy, software protection, online copyright infringement require innovative solutions. So when you look at these challenges, then this issue comes before the nations at a national level, at a global level, that how to protect all those challenges in the form of digital piracy, software protections, copyright infringement. So there is a need of some innovative solutions. And that's why you'll find it various tools were came into picture, that how to detect, how to check, how to protect the copyrights. Another important aspects I would like to discuss with you, that is trade related aspects, TRIPS agreements, that it's a very landmark global IPR governance. TRIPS harmonizes IPR standards across member countries, making it one of the most comprehensive international agreements on intellectual property. It introduces uniform protection for patent, trademark, copyright, and geographical indications, while also addressing enforcement mechanisms. Why I'm telling you that it was of such a big concern in 90s, that's why I told you that importance of intellectual property increased manifold post TRIPS agreement, because it became a very, very important for countries to sign a treaty that you are compelled to protect the patents, trademark, copyright, GIs under the multilateral regime. And there must be some enforcement mechanisms. There must be some dispute settlement mechanisms to deal with the, the issues of challenges of the intellectual property rights. And that after that, you'll find it, so many countries have passed legislations to protect, give more meaningful protections to the violations, infringement of the intellectual property rights. So TRIPS agreements also played very, very important role in areas like biotechnology, computer software, reflecting the changing nature of innovations. It emphasizes the balance of the right of creators with the public interest, particularly in the area like access to essential medicines and educational resources. So you'll find it that post TRIPS, the major development took place in certain areas, which is very, very critical, which is based on only intellectual property, and those areas need to be regulated. And accordingly, so many changes took place in the national legislations also throughout the world as far as protection of the intellectual property is concerned, because this is the impact of global perspective of the intellectual property, that every nations need to have a very robust and vibrant protection laws to deal with the intellectual property. I have also discussed with you, this slide is 5.1 is visible to you?
Yes, sir.
Okay. So now I have already given us very introductory idea about the WIPO. So this organization's dedicated organization of the UN, which dedicatedly look into the innovations, creativity, and promoting the protection of intellectual property worldwide. WIPO also develops global IP standards, facilitate international cooperations, and provide a platform for dispute resolutions. And it also helps in capacity building initiatives. WIPO assists member states to strengthening their IP framework and encourage the use of IP as a tool for economic, cultural, and technological development. So the role of WIPO is very, very important at a global level to establishes the recognition of intellectual property right. The removing legal barriers in the nascent countries for the recognition, protections of those intellectual property rights. So these organizations play a very, very important role in establishing the importance of the intellectual property rights and suggesting adequate, effective legal protections throughout the world, because that is necessary for the protection of intellectual property rights. Another the important aspects about the international organizations is world trade organizations. This also played very, very important role in at a global level to protection for the protection of the intellectual property rights. So that's why I'm sharing all these, discussing all those organizations, because these are the body which decides that what should be the policy of intellectual property at international level, and how nations should behave as far as intellectual property is concerned. One very important examples I would like to give you, that post the trademark the TRIPS agreement, we have formulated GI laws. Now you'll find it that so many product has been recognized as a geographical indications. Those products which is manufactured or produced in those areas can be marketed with authenticity, because those products has earlier been the infringed by other countries, nations. Still disputes are there, but it gives a kind of some recognition, and this happened because of the agreements made at the TRIPS. And for recognition of GI, the TRIPS played a very, very important role in establishing the geographical indications. And it becomes a huge market throughout the world. Imagine in India also, thousands of GI products are there, GI logos are there, their legal protections are there, disputes are also there. So at a globally, imagine if these organizations would not have been there, the establishment of recognition of intellectual property would have been in a different shape. So what we can say that the WTO administers the trade-related aspects agreement, which establishes minimum standard for IP protection and enforcement across its member nations by integrating IP rights into the global trade framework, and the WTO ensure a level playing field for creators and innovators. Suppose if any innovators are there, any innovators innovated a product in India, their products cannot be infringed in any part of the world, because India is a member of a WTO. Assuming that if any infringement will take place, certainly mechanisms are there, redressal mechanisms are there, grievance mechanisms are there, and states are also very, very, very much concerned about all those violations, and they raise all those issues at a bilateral level, multilateral level, to that their copyright, their trademark, their patents are abused. And certainly, now it is not possible in the digital world to violate. And that's why a lot of litigations are there also there in these areas. So it also serves as a forum for resolving trade disputes involving IP and promotes international trade by enforcing standardized IP regulations globally. Additionally, the WTO provides technical assistance and training to developing countries, helping them enhance their IP enforcement mechanism, foster innovations, and integrate effectively into the global economy. Through these efforts, the WTO plays a crucial role in harmonizing IP policy worldwide. So what I would like to say, tell you in a very brief, that WTO also played a very, very important role in protecting the intellectual property, suggesting the developing nations or developed nations about the concerns of the other countries, individuals, intellectual property, what kind of laws should be there, what kind of protections should be there. Another international organizations also play a very, very important role in protecting IPR is UNESCO. And that is also played very, very important role. UNESCO play a vital role in protecting cultural intellectual property, particularly in the realm of literary, artistic, and traditional works. Through its conventions, such as 2003 Convention of the Safeguarding of Intangible Cultural Heritage, UNESCO emphasizes the preservation of cultural diversity and heritage. It promotes international cooperation to safeguard cultural expressions and ensure that indigenous and marginalized community benefit from the recognition and protection of their intellectual contributions. This is very, very important, that if UNESCO recognizes um, a particular culture and the whole world believe in it, the protections are required. The unique cultures need to be protected, unique heritage need to be protected. I'm telling you, the UNESCO advise governments that if any heritage is there, what are the essential criteria to deal with the heritage buildings, heritage culture. So certainly it promotes a protection of the culture. It promotes international cooperation to safeguard cultural expression, ensure that indigenous and marginalized communities benefit from the recognition and protection of their intellectual contributions. That is very, very important. I'm just giving you one very simple example. Because I'm situated in Shillong, in Meghalaya, there is a one living root bridge is there. And this is a unique kind of practices is there. Indigenous technology is there, and that is recognized by the UNESCO. One village is there. That village is so clean that UNESCO awarded that village Asia's cleanest village. It is called Molino. So these recognition helps in the tourist location to market at globally, nationally, that the preserve, protect the culture, commercial benefit is possible by such recognitions. So additionally, UNESCO advocate for the fair use and access to cultural IP, encouraging sustainable practices that allow for the transmission of traditional knowledge while respecting the rights of the creators. So creators' right also need to be respected, need to be protected, and in that aspects, the UNESCO is also playing very, very important role. Now come to some of the aspects of the Paris Conventions and what important rights of a parity of patents is discussed in these conventions. First of all, when you look at Article 4, it talks about rights of parity for the patents. This Paris Convention was the first major international agreement aimed at the protection of industrial property, including patent, trademarks, industrial design. It laid the foundation for modern IP system for introducing several key provisions designed to facilitate international cooperation among member states. I'm only looking at those provisions which talk about international cooperation. First provision is, this slide is 6.1 slide is visible to all of you?
Yes, sir.
Okay. So Article 4 talk about applicants can file patents in multiple countries within 12 months, maintaining original filing date. This is very, very important. If you think that your technology, whatever you have invented, that may be very useful in so many countries, so you can file patents in the multiple countries, but your original filing date will be maintained. This is one of the important protection of the creators, inventors. And that's Article 4 talks about that. Come to protection of industrial design, it says, Article 5, industrial designs are protected under national treatment, ensuring cross-border protections. Come to Article 6, it says, trademarks registered in one of the member countries is protected in all other member countries. Come to Article 10, it says protection of GI. Article 10, GI are protected from misuse of imitation in international markets, because this is the very vulnerable sections, geographical indications, and that also need recognition at a national, at a international level. So it can, the stop imitations at international market. So this Article 10 talks about that. Come to Article 2, it's talk about national treatment. Foreign nationals are granted the same IP protection as a national in each member country. There is no discrimination as far as intellectual property honor is concerned. There should not be any form of discrimination. Imagine such a important step taken at a global level to promote inventions, promote innovations. These protections are necessary. So in 1883, we have decided that yes, these type of protections must be there. A special treatment for developing countries. Article 8 says developing countries are given flexibility in implementing industrial property protection standards. Certainly, certain leeway is there for the developing countries, those who are not a part of the developed nations. Now come to the Berne Conventions. When I say that these conventions are protecting the intellectual property at a global level, so how it is going to be recognized. So that's why we need to look at certain provisions under the Berne Convention also. When you look at Article 5, Clause 2, it says copyright protection is granted automatically upon a creation without the need for registration or a deposit. You might have seen that if someone has written a book, any person who copied that book from any part of the world, it will be treated as an infringement. And now that's why people are very, very conscious of not copying all those things. Why? Because this will violate the copyright protections. So there is no need of registration as far as copyright is concerned. Another important provision has been given under the Berne Convention itself, that is the moral rights. And 6b talks about that. Author can protect the integrity of their work, preventing derogatory treatment even after economic rights expires. So, the economic rights is available for a limited period of time. Even then, their moral rights will remain there. Another Article 9 talks about authors control reproduction, adaptation, distribution of their work, ensuring protection from unauthorized use. This right is available to the author. Author can file a case before the court of law to stop unauthorized use. Article 5 talks about national treatment. Article 5 says foreign authors are treated equally to domestic authors regarding rights and protection in member countries. That's why if someone is a creator of the intellectual property, there should not be any discrimination. No, this discrimination is possible because, this Berne Conventions protects their rights. Come to duration of protection lasts for the author's lifetime plus 50 years, extended to 70 years in many countries. So normally the time frame is also mentioned. Exclusive rights. Authors have exclusive right to adapt, reproduce, and distribute their work in any medium. So this is the exclusive right available to the author. Now come to the TRIPS agreement. What are the major, the provisions are there as far as the global perspective of intellectual property is concerned under the TRIPS agreement. When you look at the TRIPS agreement, 6.3 slide is visible to all of you.
Yes, sir.
Okay, thank you. First, Article 3 talks about foreign nationals receive the same protection for IP as nationals within the country. There is Article 64 talks about provide a forum with the WTO to resolve IP-related disputes between member countries. Then minimum standards of protection is there. Article 9 talks about that. Establishes minimum standard for protection of patents, copyrights, trademarks, and other IP. Transitional period for developing countries. Article 65, 66 grant extended time for developing countries to comply with the TRIPS standards. That's why you might have seen that the developing country has been given more cushions for the changing in their laws as far as IPR protection is concerned. Come to Article 41 to 61 requires effective legal mechanism for civil, criminal, and administrative enforcement of IP rights. Article 13 allow for exceptions in certain cases such as public health and non-commercial use. This also very compulsory licensing. You might have aware, you are already aware that how it can be exercised. So that's why exception is there. Public health and non-commercial use is there. If somebody is downloading something for learning, self-consumption, research purposes, so some fair use protections are there. So here in TRIPS agreements, in non-commercial use is there. So you'll find it at a global level also. WTO protects the rights of innovators, or it protects the intellectual property. Another important treaty I have highlighted, that is Patent Convention Treaty. And this PCT has been established in 1970, administered by WIPO, is a global treaty, simplifies the process of obtaining international protection. PCT provides a unified procedure for filing patent application in multiple countries, making it easier for inventors to seek protection in large number of jurisdictions with a single filing. Those, it simplifies the process, because certain locations, certain countries, you will find a very complicated patent filing. Still, patent filing is a very complicated process. That's why, the well experienced, well trained people are in there to deal with the filing process. So that's why this convention treaty has been signed in 70 for the filing of international applications. Article 3 details allow applicants to file a single international patent application recognized by all contracting states. For those who are contracting states, if you file a one patent, it will be no need to file a separate patent in other nation. The very important is the international search report. Article 15 requires an international search to identify prior art, access the inventor's patentability, because all these documentations are necessary when patent disputes arises between the two individuals, corporations, nations. Then these search reports are very important. And then Article 22 says details allowing applicant to enter the national phase within 30 or 31 months after the priority date. So time frame has been discussed. So at a global level, some consensus was made that how to deal with the whole functioning of the patent filing protections, and that is discussed under the Patent Corporation Treaty. Another international organization I would like to international agreements which deal with the trademark, that is a Madrid system. You should also look at it, that how it plays very important role in shaping the global perspective of the intellectual property rights. The Madrid system for trademark was established by the WIPO under the Madrid agreements. That's why it's called Madrid's Agreement, Protocol of Madrid, and it allowed trademark holder to file a single application to register their trademarks in any of the member country within the system. So they have also simplified the procedure. So the Madrid Conventions provide a unified system for trademark registration, allowing a single application to be filed for protection in multiple member countries, and it aims to reduce administrative complexities and cost of obtaining international trademark protections. The key provisions are centralized filing, allow filing a single application for protection in multiple countries, examination by member states. Article 3 deals with member countries examining trademarks based on their national laws, international registration. Article 4 provides international protection for trademark once registered and approved. Another key features of the Madrid protocols is Protocol of Madrid of 1989 is that expanded membership. Key provisions. Article 9 says that countries to join the protocol without being part of Madrid Conventions. Single language filing is there, enabling applicant to file their application in one language, English, French, or Spanish. Centralized management. Article 7 streamline the process for managing and renewing international trade under one system. Theoretically, you will find it that very detailed and enlarged procedure has been prescribed for filing. But practically, I'm telling you, when one multinational corporations working on other nations, then they need such type of cooperations for their protection of their intellectual property. And that's why these Madrid protocols protect their interest. And that's why they used to have a very detailed procedure prescribed under these protocols to deal with the intellectual property. Come to the another aspects has been given to me about the how IPR play a very, very important role in intellectual environment protection of the environmental law, and what is the relation between intellectual property and environmental law. That is also very, very important, because why we need a more and more advanced technology, because it is going to protect our environment. I have given you one example of technological innovations are required in the case of reducing, minimizing the vehicular pollution. And for that, certainly, if better technology, advanced technology, intellectual property is available in the market, certainly is going to help in protecting the environmental law. So when we look at the role of intellectual property, it played very, very important role. And that's why nations at a national level, at individual level, at a company level, at a society level, at every stage, you will find it promotes innovations while addressing the global challenges. IPR incentivizes the creation of green technologies by granting exclusive rights to inventor. Environmental law, on the other hand, focus on sustainability, regulating activities that impact ecosystem and natural resources. Together, they contribute to developing eco-friendly innovation while ensuring environmental protections. Today, you will find it most of the innovations are basically to protect the environment, because this is also one of the very, very important concerns, that we need better technology, we need more innovations to protect our environment. And certainly, intellectual property is going to play a very, very important role in protecting the environment. And that's why you'll find it. PCT also facilitates international green technologies, ensuring innovators can safeguard their inventions globally. Similarly, the agreement TRIPS encourages the transfer of environmental sound technologies to developing countries. That's why always you'll find that when head of the developed nations and developing nations meets, they talk about the technology transfers, because green technologies, a lot of issues are there. You might have seen that one of the agenda of the recently, they highlighted by the president that he's going to withdraw from the Paris Agreement, because it gives a responsibility to all the developed nations. Because the technology issue of technology transfer is there, issue of patent intellectual property is there. So certainly the TRIPS agreements try to they encourage transfer environmental sound technology to developing countries. Only try is there. There's still a lot of the challenges are there in the transfer of the technologies to the developing nations. And the Paris agreements also highlight the importance of technology transfer for combating climate change, emphasizing international cooperation with the IPR framework. If you go through the Paris agreements, you'll find it that only the certain areas which concerns the developed nations, those countries having huge intellectual property protections, rights, they think that their rights are infringed if they share all those technology. Favorable terms and conditions, they are always negotiating and looking at it. So the IPR play a very, very crucial role in protecting the environment. When you look at the another important treaties like a Nagoya Protocol, ensure fair sharing of benefit arising from the use of genetic resources, because how to share the benefit arising out of genetic resources. On these aspects, Nagoya Protocol is there. This protects biodiversity while respecting the intellectual property principles. The clean development mechanism under the Kyoto Protocol further links IPR with environmental law by enabling patent technology for carbon offset projects. Why I am discussing here environmental law? Because most of the technologies are very, very helpful in protecting the environment. So that's the relationship is very, very important to understand the global sustainability. Now we should also look at the current global challenges. That what are the current major global challenges we have, and that can only be resolved with the help of innovations, with the help of intellectual property, new type of intellectual property created to solve all those problems. So this 7.2 slide is visible to all of you, sir? Is it visible to all of you?
Yes, sir.
Okay, thank you. So intersection of IPR and environmental law faces several challenges, especially a corporation patent, critical environment technology, and genetical resources. So patent on renewable energy technology such as solar panel, wind turbine often hindered widespread adoption due to high licensing fee. This creates a barrier for developing nations that cannot afford these technologies, delaying climate actions. You might have seen that green technologies, how strongly India is advocating for green technologies. The putting a lot of resources in research and development of such technologies, because without such technology, the requirement, future economic need, economic growth requirements cannot be fulfilled. Another challenge is biopiracy presents another pressing issue, that is corporation exploits genetic resources, particularly from biodiversity rich regions, without proper consent or benefit sharing. For example is neem and turmeric biopiracy case. So while these patents were eventually revoked, the case highlighted loopholes in the global IPR framework. Certainly, unless frequently these global uh, framework also need to be revised, updated according to the changing times, and that's why various uh, regulations, different treaties are required at international level to deal with such issues. Recent case also underline conflict between environmental law and patents. For instance, Monsanto patent on genetically GM crops led to a legal dispute over farmers' right to environmental consent. Critique argues that GM crops, while innovative, may harm ecosystem, increase dependency on patented seeds. Privatization of water and other essential resources is also there. Do patent raises ethical and environmental concerns? For example, Nestle faced criticisms for seeking patent of water purification process, viewed by many other basic human rights. So certainly, these are the challenges areas that new technologies are coming, which restricts, contradict with the certain basic human rights also. So when we look at the relationship between IPR and environmental law, we should also look at the exploring possible solutions. And for that, I may think that addressing the challenge at the intersection of IPR requires multi-pronged approach, because we cannot look at only at one angle. 360-degree angle is required to deal with all such things. So fostering open innovation, green technology is very, very crucial. That's why you'll find that focus of Government of India is there as far as green technology is concerned. And at a global level also, such promotion of such technology is there. Government international bodies can promote patent pooling and collaborative licensing model where innovators share environmentally significant technology at a reduced cost. Initiative like Eco Patent Common, which make green patent publicly accessible, set a positive precedent. And theoretically, it appears to be very good, but at a practical level, a lot of difficulties are there. That's why possibility we need to look at it, how it can be deal with. A strengthening benefit sharing mechanism under the frameworks like Nagoya Protocol can combat biopiracy. Certainly, we have a now biological diversity law is there, biodiversity board has been established. but how these boards are going to function, how stakeholders, take it things seriously as far as benefit sharing is concerned. That is very, very important. The indigenous community receive fair compensation for their traditional knowledge, will foster equitable use of genetic resources. It's a very, very important to deal with such thing. Another reforms possibility may be found that the TRIPS agreements at an international level, if cooperation is done to transfer of technology, it will help the developing nations, and this is necessary. But those who are the creators of intellectual property, they are not agreeing right now. So more and more negotiations is required. By incorporating compulsory licensing provision for green techno, countries can address environmental challenge without breaching IP laws. Theoretically, it may appear to be very convincing, but practically it is very, very difficult to apply the compulsory licensing, because compulsory licensing may be used as one tool for you know technology transfer, but major nations are not agreeing on it. You see that one of the major patent holder country wants to withdraw from such type of agreements. So initially, during first term of presidency, also they withdrawn. Then again, when Joe Biden came, they agree, adopt. Again, this government is going to withdraw. So political issues are also there. The nation's economic concerns are also there, and big corporates invested huge resources in the research and development. They do not want to share these technology without exploiting the economic resources for such technologies. Another possibilities may be the incentivizing environmentally responsible innovations. Do tax breaks and subsidies for green patent can motivate corporations to prioritize sustainability, strengthening environmental law to regulate patent technologies with significant ecological impacts, such as GM crop, can further ensure alignment with the IPR environmental goals. You'll find it that if favorable tax policies can also, promote more and more innovations, and in that directions, you will find it that at a national level, at states level, at institutional level, promotion of patenting. That's why in every university you'll find that intellectual property cells are there. Earlier it was not visible. If you look at any university, you'll find that one intellectual property cells are there. The researchers are doing research, they are patenting. Earlier people were not aware, concerned. Governments were not the suggesting that unless we are having our own technologies, we cannot develop at a pace which is required. So certainly tax breaks, subsidies, if any company is promoting more and more research in green patenting, some tax concessions, all those things can attract people to enter into this area. And one, I may think that the creating global ethical guidelines is also necessary for patenting. Is essential resources like water will help balance innovations with human right and environmental sustainability, because certain areas are of very, very importance as far as patenting is concerned. Certainly it affects the society. If more and more monopoly would be created, it create the human right problem also. If right now we are facing that, suppose a company developed one water purifier technology. So what happened? Everywhere it was so much commercialized that if someone is not the taking it very, very seriously, the so many people could not get wastage of water. you know the uh, the water is something which is should be freely available to majority of the people. They are basic human rights, because some people say that these waters need to be protected. And because water is not required only by human beings, animals. Water has on water, only human has no control over it. Only they don't have a right over it. Other animals, other living creatures also have a right over the water. So lot of human rights issues are also there. So that also need to be looked into it. Now come to the another important area, that is how to deal with the relations between the intellectual property rights and business law. And this is of very important concerns that when we talk about intellectual property rights are fundamental to modern businesses. Now, this is one of the important aspects all of us need to agree that modern businesses can only run on intellectual property rights. Assuming that you cannot flourish in the market by just copying somebody or off patented product if you manufacture, certainly it will lack in technology. Certain innovations are required. So fostering innovations, safeguarding competitive advantage, and driving economic growth is necessary if there is an intellectual property rights available to the individual, company, or nations. By granting creators exclusive rights over their inventions, trademark, design, and creative work, IPR ensures that business can monetize their innovations while deterring unauthorized use by the competitors. That's why you'll find it most of the disputes as far as IPRs are concerned between the competitors, because the if creators of the intellectual property could not able to exploit within a reasonable period of time, then they think that it affects it create deterrence for the future researchers, future innovations. So they are very, very concerned about the protection of their intellectual property rights. So you'll find it that commercial exploitation of intellectual property is a big area where the concerns need to be addressed through the mechanisms, and that's why TRIPS played very important role. Other organizations I have discussed, that is the region these organizations were established to cater the need of a area of a dispute between the IPR and the business law. That's why when you look at the TRIPS agreements, certainly it supports businesses, and that's why global IPR law mandate minimum standard for IP protection across WTO member states. TRIPS provision ensure that business operations internationally benefit for consistent IP protection, bolstering confidence in cross-border investments. For instance, Article 27, all of you are aware of it. TRIPS mandate patent protection for any invention offering business exclusive right to technological advancement. Madrid system, administered by WIPO, allow companies to register trademarks in multiple countries with a single application, simplifying global brand management. Copyright laws such as those under the Berne Conventions protect creative work like software, ensuring business in creative industry to secure royalties. So these are some of the important concerns of the businesses which can be regulated through the better IPR management, and creators of the IPR want that very stringent, very strong, vibrant IPR policy should be adopted, laws should be adopted in that country so that their interests should not be uh, violated. When we talk about the challenges, what are the global challenges? Certainly, there are a lot of advantages to the um, businesses as far as intellectual property is concerned, but certainly um, certain challenges is also there, and that is patent thickets, where overlapping pattern make it difficult for business to innovate without facing litigations. For example, the pharmaceutical industry often face challenges when attempting to develop generic drug, as in the landmark Novartis versus Union of India case. We are only manufacturing most of the off patent pharmaceutical drugs, generic drugs. So the a small tinkering in the product, if those things is recognized, then certainly it may affect the businesses. And that's why in the Indian Supreme Court rejected Novartis patent application for its cancer drug Glivec, citing a lack of enhanced efficacy under Section 3D of the Indian Patent Act. So you'll find it that certainly these concerns, When you look at the American reports, they say that in the Indian standard of IP protection is very weak, but that is not the case because they have an apprehensions that the very robust laws are not there. That's why certain countries are very hesitant to transfer technology. If we transfer, it can be these technology can be abused. The, certainly it will be not protected thoroughly, and you'll find that when this case Navratis, all of intellectual property law students knows this case, how tension is created in the whole world by this case, that India as a country is not respecting the vibrant patent law, but that is not the case. But people have raised concerns about that. Another important area is the digital piracy. This is a big challenge, and counterfeit goods are other posing challenges for business. For instance, major entertainment companies loses billions annually due to unauthorized distribution of copyright content online. Similarly, e-commerce platforms often struggle with the sale of counterfeit products, damaging brand reputation and consumer trust. This is a very challenging area, and this is the area where new thinking, new innovations, and new development is required. Whenever people are buying product on online, they are not sure it's a first copy, second copy, third copy, or original one. So unless you are not buying on from the website of the company, you are not always sure that whether you get original product. So branding trademark becomes very important issues now, because rampant digital piracy there, counterfeit goods are available in the market. There are certain countries, places, they don't have any respect for all those things, and they promote all such kind of illegal activities. Another important issue challenge is monopolization of critical technologies. You might have seen that our honorable prime minister, whenever they meet at a global summits, G5, G8, or global summits, they always talks about that the developed nations should share the technology with the developing countries, because they have their responsibility to deal with the problems of the world. Mostly what happens, all these IP portfolios are owned, amassed by the tech giants, and they are not interested in sharing it without uh, exploiting the economic resources they use for developing such patent. And because they know that once they share, they could not compete with the smaller business. And that's why another important case I would like to tell you, just to refresh you, that you must read Apple versus Samsung case, and how a smartphone patent have showcased the competitive tension in high-tech industries, emphasizing the need for clear IP boundaries. Because once any company manufacture one's phones, they need a, let's say, 5 to 6,000 patent used in one phones. So always, the overlapping conflicts are there. Another important area that I just want to highlight to all of you, that how this, in the age of artificial intelligence, the current intellectual property regime can be left with the protections to the intellectual property owners. And the blockchain is also going to pose big challenges. And certainly, it creates a big tensions among intellectual property owners, that what will be the fate of their patent. The ambiguity around patentability and ownership of AI-generated innovations complicate matters. Suppose if any new technology innovations is done with the help of AI, then how this patent rights should be granted, whom it should be granted, all these complicated issues also need a global consensus to deal with such problems. And that is one issue just I want to share with you, that recent such as the US Patent Office denial of patent for invention solely created by AI system is one of the very important concerns, that how to deal with AI and blockchain, which they are going to pose the challenges. Another important challenge is solving these challenges as far as business is concerned is that patent reforms should aim to balance innovation and public access. This is one of the very important things. Then only we can able to utilize the innovations effectively for the public purposes. And that's why stricter scrutiny for patent application, as India has done with the Section 3D, can prevent the misuse of patent, especially in critical sectors like pharmaceuticals. The business and government must leverage technology to combat IP infringement. Blockchains can be used to track the origin of goods, ensure authenticity, and reduce counterfeiting. A smart contract could also simplify IP licensing and royalty distribution, reducing disputes and administrative overheads. So this is also a big challenge, how to uh, deal with it. And there is a need of more collaboration among IP stakeholders is essential. Even the TRIPS agreements took place in 1994. After that, also huge technological development took place, and for that, the different new types of infringement coming into picture, how to deal with it. So that's why international cooperation is required, such as AI generated work, digital piracy. Additionally, international like WIPO can facilitate technology that ensure equitable access to critical innovation while safeguarding IP rights. So these rights are okay, protections are okay, but in the age of AI, how these protections are effective enough to protect the interest of the IP creators, innovators. So that is also very, very important. So there is a need of international treaty, corporation treaty at a global level to deal with some these challenges. The only I have discussed theoretically. So now I would like to discuss with you some cases that how these issues are dealt by the court. One very important case, Google versus Oracle. Most of you have read it, decided by the US in the USA court. So just I had highlighted that this case revolve around copyrightability and fair use of software code. Oracle sued Google for copying Java API code to develop the Android operating system. The US Supreme Court ruled in favor of Google, holding that it is use of Oracle's code constituted fair use because it was a transformative and essential for compatibility and innovations in the business of software development. So how the courts have, they decided the fair use. And what happened? They clarified the scope of fair use in software development, a critical intersection of intellectual property rights and business innovation. Allowed business to use APIs under fair use, fostering technological advancement and reducing monopolistic control over the software components. That's why you will find it in the software world. The open source softwares are freely available. Anyone can use it and create another product. So they say that development is not possible. Business will not grow if such monopolistic control over software components would be given. And that's why it was covered under the fair use. This is a very good example to understand the need of the society, need of the development, need of the further innovations and more intellectual property creations. Another case I would like to highlight you, that is L'Oreal's SA versus eBay International AG case of 2011. This case was decided by the European Court of Justice. So summarily, just I'm highlighting here, this case addressed the liability of online marketplaces for trademark infringement. L'Oreal claimed that counterfeit products were being sold on eBay. The ECJ ruled that online marketplace could be held liable for facilitating trademark infringement if they were aware of such activity or failed to act upon notice. So what happened in this case? Strengthened the responsibility of e-commerce platform to ensure that their business do not infringe intellectual property right. This is a very important case where the intermediaries were telling that no, we are not responsible. Who is coming, who is selling on my platform? We are not responsible. European court said no. It is your duty to ensure that IP of the people should not be violated. and established a precedent for balancing trademark protection and growing of online marketplaces. So this is a very important case where court decided to say that no, you cannot escape from the liability that intellectual property rights of innovators or business do not compromised, even if it is online sale is there. When you talk about the IPR and artificial intelligence, we should also discuss that what is going on at a global level as far as intellectual property and artificial intelligence is concerned. The intersection of AI and IPR has emerged as a critical area of focus in the modern era, presenting both opportunities and challenges. AI-driven innovations from generative algorithm to machine learning models are transforming industries by automating processes, creating new products, solving complex problems. However, this rapid evolution raises pressing questions about the adequacy of existing IP framework in protecting AI-generated works and inventions. Because these AI and IP, certainly artificial intelligence may and violate the intellectual property rights. How to deal with such challenges? There is a need of some more thinking to formulate policy on AI and IPR, that because AI is also need of the hour, and how to harmonize the conflicting balance between the IPR and AI, that is also very, very important now. So the one key issue is the ownership of IP generated by AI. Current IP law typically requires a human creator or inventors, leaving ambiguity around the patentability of inventions solely created by AI. For instance, the denial of patent for AI-generated work in case like Davos has sparked global debate about whether AI can be recognized as inventors. Because this IPR protection can only be given to human creators or inventors. If it is created by AI, then who will own the IPR? That is also very important questions. Additionally, AI use in analytical vast amount of data, raising concern about the copyright infringement that I have already told you. Machine learning often involves training on copyright material without explicit authorization. To address these challenges, policymakers are exploring reform to adapt IP frameworks, proposals in granting limited rights to AI-generated work, and establishing clear guidelines for AI use is in creative and innovative process. This evolved intersection of AI and IPR, certainly it will significantly influence the innovations and the growth, because we cannot able to stop the pace of IPR and artificial intelligence growth in the artificial intelligence. Another judicial opinion over AI and IPR case is the one important landmark case is there, Naruto versus Slater. This case was decided in the USA. Although not directly related to AI, this case about a monkey taking a selfie highlighted the principle that non-human cannot own copyrights. The ruling indirectly influenced how court may approach AI-generated works. In this case, US court held that copyright protection is reserved for human, providing a precedent for AI cases. So the demonstrated the human-centric nature of copyright law and their implications for AI, showed the importance of having a human creator for the created work to enjoy copyright protections. Here also, this issue came before the court, and court said that these laws are only protecting the creativity, creations of the human beings. If human intervention is not there, no intellectual property rights can be granted. Another case I would like to discuss with you, that a judicial opinion over AI and IPR is there, that this case was decided in 2020. Stephen L. Thaler versus Comptroller General, Patents, Design and Trademark. Here what happened? Dr. Stephen Thaler filed a patent application naming Davos, an AI system, as the inventor for inventions like a food container and a warning light. The applications were rejected in multiple jurisdictions, including the UK and US, on the ground that an inventor must be a natural person. The court upheld the requirement for human inventorship. However, Australia briefly recognized Davos as an inventor before its federal court overturned the decisions. So it sparked the global debate on whether AI can be recognized as inventor under existing patent laws. Just I would like to give you a clue that what should be done, because whole world is not very seriously looked into it, because the IPR has started created with the help of AI tools, and if it comes for protections, how it can be protected. Till now, we know that I don't find any provisions, any treaty, any cooperation treaties, legislations, regulations, policies to deal with the, the IP protections created by AI. Another case on AI is Shenzhen Tencent versus Shanghai Yongguan Technology. Most majority of you might be knowing that Tencent AI system created a financial report that was copied by a third party. Tencent claimed copyright infringement, argued that AI output belonged to the company. The Shenzhen Intermediate Court ruled in favor of Tencent, recognizing limited protection for the AI output as a work for hire created the company's directions, set a precedent in China for granting some IP protections to AI generative work under corporate ownership. So some development started in some locations. Again, I would like to discuss with you this Samsung versus Apple. This case focused on the calculation of damage for design patent infringement. Apple had accused Samsung of infringing on its design patent for the smartphone features. The Supreme Court railed that damage should not be based solely on the total profit for the sale of the infringing product, but rather on specific patented components' contribution to the product. See the creative interpretations. The earlier they were asking that whatever profit you earn, that you share. The court said that no, the importance of that product which has been used in the cell phone, that also need to be considered. Refine the methodology for determining damages in design patent case, protecting business from disproportionate penalty. The ensure that intellectual property law remain fair, does not stifle competition or innovation in the tech industry. So idea is that compensation should not be such that company comes to an end. It should be fair also, or it should not restrict innovations in the tech industry. Another, the recent development in the field of IPR, I would like to discuss with you, that is WIPO Treaty of 2024. WIPO member countries came together to sign a new treaty, that is intellectual property, genetic resources, associate traditional knowledge, to address the interface between intellectual property, genetic resources, and traditional knowledge. And the first WIPO treaty to include provisions, sorry, specifically for indigenous people as well as local community. The treaty will enter into force with the 15 contracting parties in the initial stage and will establish international law a new disclosure requirement for patent applications whose inventions are based on genetic resources and associated traditional knowledge. So this treaty has a very limited contracting parties, but still one advancement in the area that if any genetic resources used in the patent, it must be reflected in the patent application. The treaty addresses situations where a claim invention in a patent application is based on genetic resources. Each contracting party shall require applicants to disclose the country of origin or source of genetic resources. So from where country of origin is their source of genetic resources is there. So this treaty, this recent development, this recent policy helps to protect, the infringement of the biodiversity or biopiracy. It's able to check on the biopiracy. Another policy has been drafted, that is Indo-Pacific Economic Framework. This Indo-Pacific Economic Framework talk about the strengthened IP standards across member nations, focusing on area like enforcement mechanisms, digital IP protection, anti-counterfeiting measures, align IP framework among Indo-Pacific nations with the global best practices, boosting trade and investment, aim to curb piracy and counterfeiting, particularly industry like technology, entertainment, and pharmaceuticals. So this policy has been developed by the United States, that how to deal with the intellectual property infringement, the particularly piracy and counterfeiting of technology, entertainment, and pharmaceutical sections. Another is Unified Patent Court, is a common supranational patent court of 80 member states of the European Union, which opened on 1st June 2023. UPC comprises of court of first instance, a court of appeal in Luxembourg, an arbitration and mediation center, and a common registry. It hears cases regarding infringement and revocation proceedings of European patents, regular European patents, unless they were opted out, and unitary patents. A single court ruling is directly applicable in the member states that have ratified the UPC agreements. It is an intergovernmental treaty in February 2013 by 25 states. All then EU member states, except Spain, Poland, and Croatia. The UPC enters into force after meeting three predefined conditions on June 1, 2023. What I would like to tell you that this is not something that internationally, globally, people are sitting idle and they are not searching, looking, innovating new mechanisms to deal with the disputes, infringement, how to check infringements, and how to find out the effective dispute settlement mechanisms for the violation infringement of the intellectual property rights. So now come to the last part of my presentations, that when you look at the global perspective of the intellectual property rights, it will play very, very important. These frameworks play a very, very important role in fostering the innovation and economic growth, establishing the intellectual property protections, and facilitating international trade also. Because without protecting intellectual property, facilitation of international trade is not possible. And in that perspective, TRIPS and WIPO has played a very, very important role. These frameworks provide a unified system, and that encourages cross-border collaborations while safeguarding creators' rights. It seeks to balance these rights with a societal interest, addressing the critical issues such as public access, dissemination of sustainable technology, and certainly the dynamic nature of the technology, particularly in the field of artificial intelligence, biotechnology, certainly is going to pose a very significant challenge to the framework, necessitating adaptive mechanism to address the complexities of emerging innovations. Of course, enforcement remain a very critical aspects, as effective measures against counterfeiting, piracy, and unauthorized exploitation are essential to maintain confidence in the system. And to remain relevant, the global IPR framework must embrace inclusive participation and reform, ensuring it reflects the diverse need of developed and developing nations alike. So when you look at the global perspective, unless having global protections, intellectual property cannot be protected by having only national framework, national legislations, national domestic framework, international consensus, because the nature of the intellectual property is such that it requires international global recognition, global protections. Then only the innovations and the more protections, innovations, and more creation of these intellectual property happens in the society, and it is one of the essential criteria for economic growth or for the development, for the developing nations also, in particular, to stand on their feet to deal with the challenges, the problems of their country, their society. Now I'd like to, this is the presentation on my part. Now I would like to ask all of you that if you have any questions, then you can ask and we'll discuss. Thank you.
Thank you so much, sir. Dear participants, if you have any question, you can either raise hand or put the questions in the chat box. Yes, Janet Parveen, ma'am, you can ask question.
The participants are requested to they can even use the chat box to type their questions. Sir, in the meantime,
Yeah,
may I have one clarification, sir? Actually, I have very little knowledge with regards to
yeah,
this international competition law. So,
yeah.
how this IPR is interrelated with international competition law, and what are the major provisions in if there is any such kind of interrelation, sir?
The as far as competitions are concerned, the IPR, when you are going to deal with the IPRs, uh, IPR need to be only dealt with the various conventions and treaties. Normally, the we have a now multilateral treaties, but most of the countries dealing all these through the foreign trade agreements now. So these protections, even any international competition treaties or fair use is there. If a sovereign nation is not going to follow, there is no mechanism available to the nations. You might have seen that today throughout the world, different protectionist approach is developing now. National interests first concept is emerging now. So what is going to happen, even if international treaties, multilateral treaty is there, if a powerful government came into picture and they say that I'm not going to obey, I'm not going to follow. You might have seen that how TikTok has been compelled to sell their stakes to the US governments, and some of their business people is willing to buy the stake in the United States. So this, when we talk about international competitions, they are also uh, very visible. Laws are not there, bilateral treaties are there, multilateral agreements are there, but it's a very, very weak and very, very uh, ineffective kind of protections are there. That's why the rise of multinational corporations are such a such a strong phenomena that even nations could not able to stand in front of their policies. They are so powerful that multinational corporations dictate the business policies, business terms, and even any elected government is not in a position to the stop their policies, programs. You might have seen them so many cases, particularly the issues came particularly in India also. Example of Nestle's product is there, example of Coca-Cola products are there. The because of the influences, political influences played very, very important roles, because you might have seen that whenever two business head of the nations meets, along with them business delegates also visit uh, those nations, and they try to negotiate. Recently our honorable prime minister is going to attend the conference in Paris. So what is the objective? That bilaterally, because whole world is giving more and more importance to bilateral relations rather than multilateral relations, because globalizations, in a one way, people are promoting globalizations, other way it is fading also, because that's why there is a need of more and more the foreign trade agreements with that nations, because real trade is going to happen with the help of the bilateral corporations. So, the competition laws are there, but it's a very unfair. It could not able to create a deterrence. That's why during presentations I have discussed that only having these conventions is not going to protect the rights of the creators. That's why small innovators, when they innovate things, they could not able to sustain in the markets. How acquisitions and merger is going to take place? Most of the startups are funded by these multinational corporations. When they grow, immediately takeover took place. So where is the competition? Whole business sectors, you will find it that there are few monopolistic the players are there, and theoretically you may say in a treaties, certain provisions are there in TRIPS agreements, other specific treaties are there, but in a real sense, you don't find any such uh, deterrence, credible deterrence to deal with the competition at international level.
Thank you, sir. I think there is a lot number of thanks and greetings in the chat box for your session, and this shows a very that they have been very much enlightened. So there is a question also.
Yeah,
Just
So the question is, are there any challenges and opportunities in harmonizing IP laws globally?
yes, of course, challenges is there, because the reason is we are a member of a developing nations. We want that whatever technology, green technologies. So the biggest challenge is, the in the area of environmental concerns. So we want that these technologies should be transferred at a concessional rates. It should be favorable to developing nations. Developing nations could able to afford such technologies, but a lot of resistances are there. They are saying, no, we are not going to share these technology. So what options are available to all the developing nations to innovate, do invest a lot of resources in the research and development of those technologies to come up with the new innovative ideas, and this is possible with the help of the technology, digital revolutions. And this is happening now. So many technologies, because you keep technology for how long you will keep technology. Another technology, suitable technology can be developed in other parts of the country, because technological business, the IPR business is a very challenging, also very dynamic. Also, I have already discussed during my presentations that it's not easy to the bring out the intellectual property where critical areas of concerns are there. So when one nations or one company come up with it, they are hesitant to share it, and because they have a power, they have a economic resources, the bargaining capacity of developing nations are very weak. So they are negotiating, but still consensus has not arrived, and all developing nations are facing challenges. And in this polarized world, the bargaining power, or the negotiating powers of developing nations are so weak. You see how the violation of human rights is going on in United States of America. Someone has illegally reached there. How badly, by violating all the norms of the human right there, the sending back to their country of origin in a whatever you may call it. If you apply the human rights standards, certainly it is a inhuman, degrading treatments to those illegal immigrants. So what we can say that certainly there is a block, there is a resistance between the creators of intellectual property rights and the developing nations users. So negotiations are going on at a national level, international level, in G5, G9, G plus 5 plus, various regional treaties, all those places, that how to tackle, how to deal with such problems.
Okay, sir. Thank you. Pankaj
Yeah.
sir has raised a question.
Yeah.
First of all, very good afternoon to you, sir, and thank you very much for a enlightening session. I am Dr. Pankaj Rai here.
Yeah.
So it's my honor and pleasure to listen here once again after a long time.
Yeah.
In some occasions, I have met you in Nehu, sir, since I'm also the product of Nehu.
Okay. So nice.
And not frequently, but in some occasions I met you. So
Okay.
it's a very nice opportunity to hear you, sir. And my question is,
Yeah.
so far IPR is concerned, sir, is there any role of international justice and Interpol? It's just like a layman's question,
So
but
there's
I have some
No.
inquisitive.
You have very good questions. The Interpol is looking at the criminal matters only. Certainly, they have a role. The infringement of IPR is a very big global concern. And, the violation of intellectual property rights is going on rampantly throughout the world, particularly after AI. The all copyright, the one example is pseudo library. The any author's copyright, the or you'll easily, the libsyn is there. So many book fees there. You can download, the any material. Earlier, uTorrent was there. Any musical, the musical compositions you can download through the various technologies are there. The now the question is, once it is in the domain, how AI is going to use such technology. This is also a big challenge, and means how we will punish AI for the violation of intellectual property rights. This is a very challenging issue. Another is, the huge violations are going on throughout the world, particularly music industry, film industry, publication industries are facing huge challenges as far as infringement of intellectual property is concerned. But certainly, that's why all these, the violations, they need to be discussed, because more awareness is required, because it is a property of the creators, and these properties should not be appropriated without, certain economic criteria imposed on the acquirer of such illegal intellectual property. And that's why a lot of cases are also filed, but remedies are very, very poor because of effective implementations. Vibrant judicial systems are required, and see the condition of judicial mechanisms we have in a different part of the world. We all know that. So the idea is that Interpol, if it is certainly, if a infringement of intellectual property at a big way is there, then these international organizations may take the multinational corporations may take help of Interpol organizations to check on the proliferations of check on the infringement of the intellectual property rights in that area. Certainly, Interpol can be involved in the protection of, but Interpol normally, they is not looking at business concerns, violations, unless states are involved in it. But certainly, states are having, big, the coordinations. That's why I told you that trade agreements are increasing. Whenever any country sign a trade agreement, they say that you have to respect, you have to protect our intellectual property rights. In every agreement, IPR clause is always there, whether it's a smart contract or it's a ordinary contract. Why? Normally, I'm telling you, if someone is going to work in a law firm, they have to sign that non-disclosure agreements. You cannot use the intellectual property of the organization for your own personal purposes. So certainly use awareness, and it depends upon the concerns. Of course, if magnitude of a violation is such where involvement of Interpol is required, certainly nations can request, and it can be done.
Yes, sir. I have one subsequent questions.
Yeah.
So far, some software are concerned, there are some sites. I
Yeah.
don't want to name the sites from
Yeah.
where we can freely download even the commercial softwares also, which are
Yeah.
very commercially very viable and very high price in the market. But
Yeah.
if we visit those sites, we can freely, just simply freely, we can download it. And there are some mobile applications also.
Yeah.
Some are based in Pakistan, some are based in Russia.
Yeah. Yeah.
So probably, I think you can understand, sir, what I meant to
Yeah, I understood.
point it out
I
here.
understood.
Yeah, yeah.
That's why my opening remark was, sir, that IPR violation is rampant throughout the world. And that's why the more and more innovations, because the if any company invests huge on resources, research and development, it's a highly risky business. And after that, if any possible lead comes, patent comes, and then if they could not commercially exploit, do you think that in the next project they will invest money, new things will come in the market? Answer is no. That's why both concerns are important. But at the same time, the high pricing of the intellectual property products is also big concerns. And these multinational corporations are exploiting their positions in a such a way that the developing countries are facing, because their concerns are different. They are not looking, they are only looking at purely business interest. The human interest is there, environmental concerns are there, human rights concerns are there. That is not within their agenda. And that's why they are not willing to share anything, any clean technology to the governments, are requesting to all those multinational corporations, big corporations, those owns the trade through the governments, and they are not responding it. Certainly, whenever these websites, whatever you talk about in websites, frequently, they get used to change. Because why I'm telling you, that earlier book Z was there, then that was closed. When it comes to the knowledge, then book fee, then so many. Just I don't want to name much, but telling you, these were the popular sites where people were downloading the copyrighted materials. Certainly, you have correctly stated that certain Russian sites are there, certain Pakistan sites are there. Even this, because these countries have no respect for the intellectual property rights. That's why you'll find it. There is a minimum investments in those countries by the multinational corporations, because they know very well they are not willing to negotiate with those governments. Because when you we ask for the investments, foreign direct investments, this is the one of the important questions we have to answer, that what is your policy about intellectual property? What is it? Because this is a big concerns of investors who is going to invest in other nations. Because being a developing nations, we need investments. So certainly we have to make a very vibrant IPR policies. We cannot do like that. Particularly, I'm telling you, in India, the infringement has been reduced. Certainly, the awareness is there. A lot of cases have been filed. Intermediary liabilities have been fixed now. The new regulations, new IT law is going to come very soon. New digital law is going to come. Data protection law has been passed. Data protection rules are going to revise very soon for better protection. So, the awareness, the through better the laws, regulations, certainly it promotes the intellectual property, reduce the intellectual property violations. But certainly we have to do a lot in this area.
Thank you so much, sir. Sir, there is a last question from Ramani ma'am.
Yes.
Anything in excess in dangerous? How about including everything in scope of IPR?
No. What can you repeat the question, ma'am?
Sure, sir. If anything in excess in dangerous, how about including everything in scope of IPR?
It's a very I could not make out what ma'am wants to say. IPR, when we talk about certainly protected rights, already recognized, already assigned to individual or corporations, person. We are only talking about those rights here. If anything is endangered, how we correlate with intellectual property rights. We are not looking in that bigger perspective. We are only looking at a very limited perspective. Once right is conferred, then those rights, how those rights need to be protected at a national level, at a global level. And then we are looking at it, what are the challenges and how to deal with it, and how to protect something, some rights, or some innovations some intellectual creative creations that need to be protected. So our canvas is a little smaller. Ma'am's canvas is a little bigger. That we are not looking at everything. We are only looking at those rights which is considered under the national laws as a intellectual property rights. Because once trademark is registered, then only someone can go to court for the infringement of the trademark. Once design is registered in their name, then only they can go for the violations. If someone has a patent, then only they can file a case for the infringement of the patent. This in limited sense, I understood ma'am's question. This is my response, ma'am.
Thank you so much, sir.
Actually, Ragini, I think Vijay Sharma has raised the hand. Vijay
Yeah.
sir, please. If
Yeah,
you
I have another meeting, Jayanto. He can write a question, and I will answer later on. I have another meeting, scheduled meeting.
Okay, sir. We'll forward the
Okay.
questions. Thank you, sir.
Okay, thank you.
So,
Thank you, Jayanto, once again. You,
Thank Thank you so much, sir, for your answering the questions and sharing your valuable insight on IPR policies and international framework global perspectives to us. This is a very knowledgeable and informative session. You have a share about IPR in details and case laws as well. You have also shared some valuable insight regarding different IPR organizations. Your words helps a lot to us and widen the scope to work on the legislation of environmental laws and business laws. Thank you so much, sir, for sharing your knowledge with us. Thank you, and thanks to all the participants to spending time and attention with us. Thank you so much, sir.
I thanks to all the participants for a patient hearing. Thanks once again. Thank you. I'm leaving, Jayanto.
Okay. Thank you, dear participants. We will be meeting for tomorrow's session at 11 a.m. Thank you.